just says it.
It seemed like in 3 different, it was like offered, or marked, offered, admitted, like one after the other in 3 separate sentences, and I didn't know if you'd have to do the mark, you know, all 3 for, okay.
No. I don't. And I'll bring some of the other court reporters or whatever that'll speak about that and what they do. You know, and everybody kind of does it a little bit different. I don't think it's a, you know, for sure rule on, you know, there's a uniform format that we have to follow, but on some of this stuff, parentheticals, you know, I don't think it's that big of a deal. Okay? Any questions about that? Kind of important stuff right there on the exhibits.
I might have missed it. I'm sorry for asking.
Mm-hmm.
Where it says when it's marked for identification, I understand that part, but when it says an exhibit may be marked for identification and never received into evidence.
Yeah.
Never admitted.
So they may just want to talk about it. You know what? What is state's exhibit number 1? Well, it's a series of 8 pictures. Okay. Well, what's exhibit number 2? It's a series of 8 more pictures of, you know, the bruising on the baby. Okay. Judge, we're going to offer state's exhibit number 2. And they never do anything with number 1. Never. Most of the time, I mean, I've had it happen, but 99 times, 98 times out of 100, they're going to offer it. But I have had where they're like, you know what, never mind. Never mind, we just won't talk about it anymore. Okay.
It's not admitted until the court says it has been officially admitted.
Yeah. Yeah. So it's not admitted until the court says it's admitted.
She actually stopped and they had kept talking, and she said, wait a second, I'll go ahead and admit that, and then they went ahead.
Yeah. Yeah. Any questions about that? Nope. See, like, I don't understand, like, some of these parentheticals here. Plaintiff's exhibit number 1, a lease dated May 1, 2000 was marked for identification. No. No. Plaintiff's exhibit number 1 was marked for identification. That's all you need to put. Not a lease, not a car, not a picture of a car accident, not a fender that they brought in. No. Okay? Any questions about the exhibits, parentheticals? Pretty easy. Keep it simple. Parentheticals showing action. I guess if you want, you can. I don't know that I necessarily do it. You know, sometimes counsel said, you know what, Judge, give me a second. I want to speak to my client. Off. Whereupon an off-the-record discussion was had. And it just comes in. So, I mean, counsel examined the exhibit. Not really. Counsel handed the exhibit to the witness. Not really. Counsel read the document. I mean, some people might see it as padding. Okay, so kind of be careful with that. You don't want to put parentheticals all the time about, you know, silly stuff. Okay, keep it simple. You know, the witness went to the blackboard.
This was, I started asking questions, but this one I was like, there's a lot of parentheticals going on that I wasn't sure were really necessary. But for example, one of our other students went to court for a competency hearing, and the defendant got up and was trying to walk across the courtroom to go ask the prosecuting attorney a question, and the bailiff ended up tackling him. For something as dramatic as that, would you put like, defendant got up and walked across the courtroom and then was tackled and violence then like ensued in the courtroom?
I don't know. I mean, I don't know how I would.
At what point are you off the record? Do you have to report the bailiff tackling said defendant?
Tackled said defendant.
I don't. I mean, I don't know. I mean, I've never had that situation happen. I never have.
I heard about that. That's what I was saying. Like, what would you?
That's interesting.
What would you
That's an
write
interesting
with
question.
it?
Yeah. I mean, and that's one. Write it down. You know, and when, you know, I get the other court reporter come speak, and we'll ask them on the defendant side. I mean, like our side, and you would think that we have a lot of stuff happen because it deals with children and stuff like that. But I mean, a lot of the stuff happens like after the hearing. You know, and then dad's like, you know, or dad has a warrant and they're getting ready to arrest him and he don't want to go, but it's already off the record. You know, the bailiffs always wait till after the hearing to arrest him. Then it kind of gets messy.
Very nice.
Yeah.
Very nice.
Yeah. So, but like, you know, some of this stuff, the witness, you know, you come back after lunch, you know what, come on back up to the witness stand. You're gonna put a parenthetical, witness goes up to the witness stand. It's already in the body of the thing. The judge has already said it. You know, come on up to the witness stand. They already know the witness is going to the witness stand, all right? So you don't need to pad the record is more of what I'm getting at. Videos or color slides are often presented during the course of the trial, requiring the use of the video playback unit and monitoring or project screen. You should note it as a usage as follows. A monitor was set up in the courtroom and Plaintiff's Exhibit 5 was played for the jury. Yeah, I guess so. Parentheticals in interpretive proceedings. Non-English speaking witnesses may testify through an interpreter who is sworn first by the clerk. The oath in the interpreter says that the interpreter will truly interpret the testimony for the person. The clerk then administers the oath. And that's just it. Mine is real simple. Whereupon the interpreter was administered the oath. Simple. Not Jose Jimenez Gonzalez was sworn as a Spanish interpreter by the clerk of the court. The witness was first duly sworn through the Spanish interpreter. Seriously? Keep it simple. Depositions read into the jury. Depositions are read into the record when witnesses are unavailable or deceased. The reading of the deposition may be done by the original attorneys who made the depositions. Ordinarily, the reporter merely notes the reading with a parenthetical. Not anymore, guys. If they read it, you write it. Okay? That was a rule that came down several years ago. As it used to be, they would show videotape depositions of people and, you know, you just kind of don't take it. Now I think you have to take it. Even if it's a video, you have to take it. So I'll have one of the other reporters come and speak about that. I've never had that happen in one of our cases either.
What if they're playing like a 911 call and you write what's said back and forth there?
Read back parentheticals. Whenever an attorney or judge asks a court reporter to read back questions and answers, it is called a readback. Readbacks are requested during the depositions and hearings to a great extent. Technically, any readback situation is at the discretion of the court and should receive his or her permission. You read back you write what was said. Okay? So you put a parenthetical, whereupon court reporter read back the question, then you write the question and the answer, if that's what they were asking. Okay? I think that came back a couple of years ago too, that we had to put the actual question in there. How it was read back. You in the front.
So back to the 911 call, if, you know, in court you can stop them and say, I'm sorry, I didn't get that, and just say that. The 911 call, they're going to be hysterical. If you don't get what they're telling the operator, what do you do in that situation?
I tell the judge I don't understand it. It's not like you have magical ears. And if you didn't understand it, more than likely the judge didn't either. Or the attorneys didn't either. And we had that happen. We had you know, where a dad called and threatened a mom. And they were like, you know, Judge, we want to play this. They were like, you know, it's not admissible. We don't know who it is. And Judge said, you know what, I'm going to go ahead and let them play it. And they played it, and it was ridiculous. Ridiculous. I told the judge, I said, Judge, I don't understand. Rewind it. Went back again, Judge, I don't understand. Rewind it. Like the third time, you know, you could kind of make out what they were saying by the third time, but we kept having to rewind it.
So what happens at that point?
What do you mean?
What happened?
Like if you don't understand it, it's like, Judge, I don't understand it. And maybe the judge understood it. When she was saying, you know, no, don't kill that baby. Oh, okay. I didn't hear that. I didn't understand that. You know, because they're, no, don't kill the baby. You know, and sometimes they're so hysterical you can't understand them. So it's like, Judge, I didn't understand that. And maybe someone else did. You know, maybe someone else understood exactly what they were saying. I don't know. Judge, I didn't understand. I didn't understand it either. Oh, I understood. She was saying, no, don't kill the baby. Rewind it. No, don't kill the baby. Oh, okay. Now I hear it.
So do you go ahead and write that in because the judge?
You write what they're saying.
Okay.
You know, the judge says, rewind it. So then you kind of go back and listen. Judge, I didn't understand it again. And the state comes in, yeah, she was saying, no, don't kill the baby. Rewind it. Rewind it again. That time you heard it. If you didn't hear it again, you tell the judge, I didn't understand it. That's not what I heard. I didn't understand that. You're responsible for that. So if it goes in there, then that means you heard it. You understood it. And it goes up on appeal because of that. And it's like, that wasn't what she said. She was like, no, kill the baby.
And all this time you're saying, Judge, I didn't get that, you have to put that.
Yeah. So you have a parent, you have a, you know, colloquy for yourself. The court reporter, Judge, I didn't understand that. Go back on, Judge. And the judge comes back in, rewind it.
Anything the court reporter says, does that go on parenthetical?
Anything anybody says. If you say something, yeah.
Oh, it goes in as regular, but not in parenthetical, so it doesn't have to
No.
be in parenthetical?
No, it's like colloquy.
Okay.
So it's like, you know, the court, blah, 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 the court reporter, Judge, I didn't understand that. The court, rewind it. Court reporter, I didn't understand it again. So you put in there, I didn't understand it again. So you, not a parenthetical, court reporter didn't understand what was going on. No, it was actually what you said. Okay? Any question about that? All right. Jury deliberations and readbacks. After all the evidence and arguments has been presented, the judge will send the jury into the jury room to deliberate and arrive at a verdict. In federal court, the custom is to swear the marshals who escort the jurors into their rooms. An appropriate parenthetical, 2 marshals were duly sworn. I don't know, I guess. I've never sat in federal court, so I don't know. At 3:30, you know, the jury retired to deliberate. Yeah, maybe. I mean, that might, you know, that's a time when maybe time is important. You know, when the jury deliberated for 8 hours. How do we know? Oh, because they said. Jury went in at 3:30 and we didn't leave till 11:30. Oh, okay. I don't know. I guess. When a portion of a witness's testimony is read to the jury during their deliberations, a parenthetical will be used to note that fact. When reading back to the jury, the reporter will read back only the questions and answers that are germane to the jury. You will leave out objections and rulings, questions to which objections were sustained, and questions and answers that were ordered stricken from the record. In most cases, you will have time to prepare your notes and read back for the jury. Parentheticals may be used to read back to the jury. I think you have to write exactly what you read back. The exact question, the exact answer, everything. It's not really a parenthetical. You can put a parenthetical whereupon the jury asks for a readback, and then you put it in there. The exact questions, the exact answers. Okay? Question and answer parentheticals. Whenever a parenthetical is considered as part of the question or answer, it becomes part of the question or answer and is not keyed on a separate line. The following examples are hypotheticals. You know, that's just it. Well, where does it hurt? Oh, it hurts right here. Right where? And you don't need to put upper chest, torso, by the clavicle, on top of the head. You just put indicating, that they were indicating. It's not your job to, well, no. He was pointing at his heart. No, it was above. It was like his collarbone. So now you're going to get into an argument about where it was. All you do is just put indicating, okay? How did you push the papers off the desk? Like this. Bless you. Indicating is what I would put. They put demonstrating, but I would put indicating or whatever. Please read the last paragraph. Okay. I don't really do that. I don't really put in a little parenthetical reading. They pretty much know that they were reading. They just asked them to read it. I don't do it. Will you please draw the line showing your movement? They already know they're going up there to draw it.
If you put indicating for that one, would that not be incorrect?
It wouldn't be incorrect, but I mean, I just don't do it. Go up to the blackboard and draw, you know, where he was. Oh, he was right here, indicating. Not he went up to draw the line. No. And it just says right there, guys, very important. The reporter must be careful to ensure that these parentheticals are not too descriptive. Okay? That is, the reporter is not to put his or her own interpretation about what the person is doing. The reporter should not write indicating the left side of his or her face. Just like I'm saying right here. And I put pointing to the heart. I'm not pointing to the heart. I'm pointing to his collarbone. And you put the heart. You know, that's not your job. What I would just put is indicating. Okay? And that's for the judge and the attorneys to indicate, well, tell us exactly where you're pointing to. Well, I'm pointing to my collarbone. Oh, okay. Then that's fine. But it's not up to you. It's not up to you to tell them where they're pointing to. It's not up to you. You just put indicating. Okay? Phonetic spellings. Occasionally a court reporter is unable to verify the spelling of a proper name or a technical word. Customarily, a parenthetical is inserted in the name or term that indicates that word is spelled phonetically, that is, according to how it sounds. This method is not used as an excuse for not researching names or terms. It is only reserved for those words or names which you honestly can't find the spelling for. For example, I believe his name was Boris Vanichulewski. When asked to spell, the witness may not know, and it wasn't found in the local, telephone dictionary. In case of that, what we do is I would put Boris Vanichulewski, and it was Bella, whatever, and then I put sick. That's where you use sick. Guys, unbelievable wealth of information on Google. If you can't find it on Google, then you sick it, okay? But like Urban Dictionary, all of that stuff, ridiculous amounts of information. So, and I had an attorney just the other day about a kid who was in Bull Ridge. And, it's like, this kid needs her medication at certain times. If not, she goes AP. AP. APEY. Couldn't find it. Googled it, couldn't find it. And it kind of came up as APEY, but you know, it was like suggested spelling. So I called another reporter. I said, have you ever heard of it? She goes, you know what? I have. So she looked it up on Urban Dictionary. Sure enough, it was there. APEY. AP. Yeah. So I mean, you know, you could have put APPIE. I don't know. Go through, try to find it. If you can't, that's when you use this, the sick. Okay? And that's the same as phonetic. Okay? The use of sick, it just said it. Sometimes an attorney may make a mistake in stating a person's name or using a date that is so blatant that anyone who looks at the record will know that what it should be. For example, if a witness has identified himself as John Doe and the attorney directs the first few questions to Mr. Doe, but then suddenly addresses him as Mr. Rowe, the error is obvious. The reporter knows what the attorney meant. Some reporters may correct the obvious error of an attorney because he or she is not under oath. Others will place the expression sick within brackets after the obvious error. The word sick is a Latin word for thus or so. Okay? Had that happen, guys. Way had it happen. My judge has done it. You know? Just happened today. You know, and there was 3 dads on the case, and the one dad, you know, Mr. Garza, and he kept talking about this Mr. Garza, and it wasn't Mr. Garza, it was Mr. Like Banda or something. And he kept saying, well, Mr. Garza, you know, and Mr. Garza this, and Mr. Garza's kids. And finally the attorney said, Judge, it's Mr. Banda. Oh. I wouldn't go through there and put the sick on there. Just because anyone who's going to read it is going to know, after reading it, the attorney goes back and corrects them. Whether you do it or not, that's what they're saying right here, to do it. If you know that it's a blatant, you know, something that's blatant, do it. I don't know. I do it when I can't find the proper spelling of something. Or if somebody says, we had a lady come in and she was irate, and this was back when I sat with Judge Sakai, and you know, she was upset that one of her kids had got hurt while in care and broke his or her arm or whatever. And you know, she told the judge, she goes, and I'm going to tell you right now, Judge, and he has a nameplate right there, and his name is S-A-K-A-I, Sakai. And she goes, I'm going to tell you right now, Judge Sakakarai. And I'm like, and he looks down at me and he's like, S-A-K. I don't remember, there was an R, a couple of R's in there, a couple of K's, I don't know. But she was just so irate, or I don't know if she was trying to be funny, I don't know. But you have to write what they say. You know what she meant. She was trying to say Sakai and says Sakakarai, sick. And it just tells the reader that the person that was saying it messed up. Or that somebody really used this word and you couldn't find it. So that's what sick is for. Okay? You in the front.
If it's acknowledged later that they messed up, you can not sick it as long as it's acknowledged somewhere in the transcript.
That's what I'm saying. That's what I was saying just a second ago about my judge using the Garza, and then the other attorney goes, Judge, it's not Garza, it's Mr. Banda. Well, you don't correct him because he wasn't saying Banda. Now you go back and correct him, which you shouldn't, but now you go back and correct him, and now in the body it's going to say, no, Judge, it was Mr. Banda. Well, he was saying Banda every time? No, you went back and corrected it. No, that's not your job. Your job is to take down what is said. That's it. Okay?
If someone keeps saying the wrong thing, if it's not a name over and over and it's never acknowledged, would you sick it that many times or just the first time?
Well, it's not really up to you because you don't know if it's wrong or not. Maybe that's what they meant to say. Now you've sicked it and people are thinking, well, he was saying it wrong. They get back that transcript, it's like, I said Garza because I meant Garza. It's not what you thought. You thought that it was Bandit. Who cares what you thought? It's not what you thought. I know what I was saying. Now you've kind of gotten in a touchy place with somebody because they were trying to say, they were saying the right thing. So you have to be careful with that. Be careful with that, you know? Any questions about that? Speaker identification. Some courts and freelance agencies, as standard practice, will indicate in parentheses who is doing the questioning after a lengthy break has occurred with an examination. In other words, if the testimony is interrupted by an objection, discussion, ruling, or further discussion, and the testimony resumes, the reporter will indicate who is asking the questions. I don't do that. I put the byline again. When they say, Judge, we object to that question. And then they go through a whole thing, well, it's a proper question. And no, it's not a proper question. It's a proper question. It's not a proper question because of blah, blah, blah. And they go on for a page, bless you. They go on for a page about why this question should be stricken or not asked. And the judge goes, overruled. He can ask a question. By so-and-so question. And he asked the question again. The parenthetical, I just do another byline, okay? And I think that's what they're saying there. English answers in interpretive proceedings. At times, a witness testifying through means of an interpreter answers in English rather than in her own native language. Some reporters put an asterisk before or after the A in which the witness responds in English. At the bottom of the page, they place an asterisk followed by the word answers of the witness in English. The way that I do it is I usually put the witness. You know, so if you know, they're going through a Spanish interpreter or whatever, and they say, well, how many times do you think you spanked that kid? Como unos 5 or so. I don't know. I mean, you know, and you have it all the time. They're speaking Spanglish, you know, and you know they answer some of it in English and some of it in Spanish, you know. And I've had attorneys say it. And you know, well, did you go through all of that discovery? Más o menos. Well, they said it. They didn't need an interpreter. It's a white guy. He's saying it, but he's just, you know, trying to be funny. He was trying to be a funny guy. Yeah, más o menos. I went through it. You write it. Write it. And you can Google it now. You can Google it now, más o menos, and it'll come up. Exactly how to spell it, everything. You know, but if they start going, well, más o menos, me fui para, you know, para la tienda en el carro, and now he's speaking in Spanish. Whoa, 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 whoa. I usually stop it. If it's a más o menos, yeah, whatever. If they're going to go on for a sentence, absolutely not. Whoa, whoa, whoa. And I've told, you know, attorneys that my machine only takes English. Speaking English. You know? And it does. You know, you write más o menos, it's going to come up mass or probably menos, like a fish. You know, it's not going to come up in Spanish. It doesn't know Spanish. Our machines know English. And if they need it in Spanish, then they get an interpreter. Okay? So, but if they say stuff like that, más o menos, or what's something short? What's something short? That people just, you know, off the fly will say, what are they? Or something like that. I don't know. I mean, you know, just trying to be funny, but they're like, yeah, you know, did you go over there? Yeah, what are they? I don't know. You know, something like that, yeah. I mean, you're going to have to write it. You're gonna have to write it.
But won't, sorry. Won't some Spanish words need some kind of little accent on it? So how do we do that in our software?
That's a good question. Some of it doesn't. Some of it won't come. But I mean, as long as you get the spelling in there of what they were doing, yeah, it'll be all right.
So you said if it's quick and short, we can look it up. What if they said something in Greek, real quick and short? That's where we draw the line clearly though, right?
You know, sometimes they'll say it. I mean, and I've had guys, you know, come in and speak German. It's like, I don't know what that is. You know, and if you don't know, you're responsible for it. I know Spanish. But if you don't know what más o menos is that, whoa, what? And what is it, más o? More
or less.
More or less. Whoa, what? Oh, more than less. Oh, more or less. Okay, I'm sorry. You know, but everybody just, you know, some people just think, well, you know, it's just kind of a given, you know, más o menos. You know, especially here in San Antonio. You know, that you're going to know that. Well, you may not. And you may be Hispanic and not know a lick of, you know, anything of Spanish. You know, and if you don't know, what? And you go in there and you put más or menos, that's not going to be good. So it's your job to speak up.
But even if you know the language and you understand it, you really shouldn't be taking it in Spanish.
You really shouldn't. That's correct. Because you're there to take it in English. You're there to take it in English. And if they don't have an interpreter there, then you're like, whoa. You know, this person starts speaking in Spanish. And I've had that happen, guys, and it happens. You know, you know, you may have a Hispanic attorney asking the witness who only speaks Spanish through an interpreter, and where they get mixed up. And they start asking the question in Spanish. Whoa. You need to ask, and usually the interpreter will stop them. No, you need to ask in English. Okay. But if not, then that's your job to stop them. Your job to stop them and, you know, whoa, you need to ask in English. That's the interpreter's job, is to interpret the answer, not the question. Okay? Yeah.
I was in court sitting with Judy, and we had a situation where both sides spoke Spanish and English, but they were both using an interpreter. And the situation we were getting into is they would start trying to answer in Spanish before the interpreter had finished interpreting, because everybody already knew Spanish and we're waiting for the interpreter to translate. So the judge keeps telling everybody, quiet, let the interpreter finish before you start objecting, and it was just, it's a matter.
And I'm telling you guys, you have complete control in that courtroom or deposition. And you better take control, because once it gets out of control, it's hard to get control back sometimes. Okay? So you stop them. Whoa, guys. Question in English, answer through the interpreter, okay? I can't take Spanish, and you just explain to them. Just explain, I can't take down Spanish. Oh, and you know, and like the attorney, he's a good friend of mine. And he just got caught up in the moment, you know, and you know, he's asking the question in English. Well, you know, did you go to the store that day? And the you know, the lady or the man is answering, and he or she is already answered in Spanish. The interpreter's getting ready to interpret. He's already asking the next question in Spanish. No. Wait for the answer. Question in English. And my judge is real good about that. And he'll, when I point to you, you ask a question. When I point to you, you answer the question. I mean, because people want to talk over one another. Not going to happen. You're responsible for that record. You are. And if you don't take control, then it's on you. Okay?
That's what Judy had the judge doing, and she had little markers. You go now, you wait it, now you go, and no, you have to.
Yeah.
It was chaos.
Yeah.
In the summer, I stopped with someone, a court reporter, for Border Patrol, and the first thing that she told me was, you're not going to take down anything unless it's in English and it comes from the interpreter.
Mm-hmm.
Period.
Yeah.
She was even, and when we got to the second guy, he looked at her and he's like, in Spanish, he told her, I know you understand everything, because they see her, I mean, she stopped, obviously, when he's repeating.
Yeah.
And they said that, like, that was the first thing, they read this spiel, like, no, the only thing they're taking down is what they say in Spanish. She is not taking down anything, she's not, I mean, it was like, I I want to say it felt forever, like 4-minute spiel, but they said it in English, they said it in Spanish.
Yeah.
Everybody was okay with it.
And your job, you know, even if you know fluent Spanish,
Yeah.
your job is not to clean them up either. Your job is to take down what they say. So if they ask a question in Spanish and the interpreter interprets it a different way, and you know what they said, and the interpreter interprets it another way, it's not your job to clean them up. Your job is to take down what that interpreter interpreted. Okay? Not like, that's not what was right. I'm going to type down what was right. No, you're not. You're going to type down what was said in English. Okay? That's your job, is to take that down. Okay? Your job is not to clean these guys up. Your job is to take down what is said. Okay? Okay, answers that have no response. Very important, okay? You know, and they may go, yeah. And it's your job. I'm sorry, you need to answer out loud or answer verbally. You know, and sometimes, you know, most of the time the judge and the attorneys are pretty good about, you know, you need to answer. You know, but I mean, to take down what? And did you get it right? Was it Was it? Did you go to the store? What? Nodding affirmatively is what I put. Did you go to the store? Nodding negatively. You know, and that's what it is. You know, keep it simple. Something just, you know, witness nods head. Did you participate in the riot? Witness nods head. That's probably better, because it's not really your job to interpret whether it was affirmative or negative. You know, your job is just to kind of say what they did. Or if they go, did you go? What's that? You know? So, witness shakes hand. I don't know. I don't even know what you would put there. But my judge would have already jumped on him. You know? No. Answer out loud. You know? Keep it simple. Another type of parenthetical should be mentioned because you may be called on to use these during the course of your career. These parentheticals seldom, if ever, appear in court and deposition work. They are restricted almost entirely to transcripts of public addresses, speeches, conventions, conferences, and meetings. In addition, they are used in closed captioning and reporting proceedings for the hearing impaired when it is necessary to capture the events. And this is on laughter, applause, music. I'm telling you guys, this year, and I'll remind y'all to do it, hopefully. But during the rodeo, they caption that rodeo, and it's neat. You can go on the internet and see it, and they're typing down everything they say. When the band comes out to play, they take all the words that the band is saying, that they're singing. And they have these little notes to show that the music is playing or whatever. It's pretty cool. It's pretty neat. That's what that captioning is. If you ever wanted to do captioning, it's a cool thing. It's cool, but it's for the elite. But it's a pretty cool thing, you know. And anybody, I'm not saying anybody can do it, but if you put your heart and soul into it, one, you can do court reporting. Two, you can do captioning. Okay, pretty cool stuff. We're going to go through it real quick, chapter 11. How to report motions. Do y'all have any questions on parentheticals? You in the front.
On page 89, it says, question, if you participate in the riot, answer witness nods head, and then the attorney comes back and lets you know if you have to answer yes or no. But it's out of Q&A form, even though it's the same attorney with the same witness. It
I don't know, I'd keep it in Q&A. You know, if he's still talking to the witness, I kind of put it in Q&A. I kind of keep it in Q&A. You know, unless the judge comes in and says, or one of the other attorneys says, whoa, 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 you need to answer, you know, out loud. I didn't understand what you said, or nodding of the head, or whatever. You need to answer out loud. If not, I kind of keep it in Q&A. You know, that the attorney asking the questions said, you know what, you need to, bless you. Any more questions about parentheticals? A lot of stuff covered in there, guys, important stuff. Okay, reporting motions. In legal terminology, a motion is a request by an attorney for the judge to make a specific ruling or to take some sort of action regarding the request. And that's all it is. So they file motions and to have things done. You know, and usually, I mean, if you ever come sit in my court and, you know, we're there and the judge is like, you know what, we want to, I mean, or the attorney's like, you know what, we want to increase visitation. Did you file a motion to increase visitation? Well, no. Well, we're just here on a 60-day hearing. You didn't file a motion. File a motion, we'll have that motion heard. So a motion is when you want something specifically heard. Increasing visitation, child support, other, God, I can't even think of some of the other things, but you know, stuff like that, okay? You want something specific, and that's what a motion is. Motions will be argued by both sides and present their case for granting or the not granting of the request. Many motions and their arguments are presented during the recess in chambers before the court begins. Motions have to be reported verbatim, which is word for word. And all arguments by opposing counsel and rulings by the judge are important matters that need to be recorded and transcribed accurately. That is true. You do, because a lot of times they'll appeal it. It may go up on appeal to another judge. You know, my judge is an associate judge, so they go on what's called a de novo, which is where they go above him to a district court. Well, you know what? He affirmed what my judge said, the associate judge. Well, you know what? We're not satisfied with that. We're going to appeal it to the fourth court. So now they go to a higher court. So that's why it needs to be verbatim every time. So the record's going up and it can be clear. Motion in limine. The Latin phrase in limine means at the beginning. A motion in limine is a motion made at the outset of a trial in an attempt to suppress damaging or inadmissible evidence that the other side may want to use. So, kind of like in the case that I got picked on the jury, this guy had a one-car accident, and he's on the side of the road. Cop comes up behind him, says, "Hey man, you know, you need some help? Are you okay?" "Well, I had an accident. You want me to call a wrecker?" "Yeah." So, I mean, he asked for the guy's driver's license to get the wrecker over there. Runs his license. Now the guy has warrants. So he puts a guy under arrest, and they were coming back saying, "You know what? That's an illegal search and seizure." He had drugs inside the car. He had drugs, a scale, a gun, all kinds of stuff. And you know, the defense attorney was trying to say it was an illegal search and seizure. So he was trying to keep that all out. So they had filed a motion in limine before the trial even started to have all of this stuff left out. You know what? We don't want them to know. We didn't want them to know that there was guns and drugs in there or whatever. He did an illegal search and seizure. Okay, that's what it is in limine. So it's before the trial even starts.
What did they decide on that? What's that? Did they count
That
that?
it wasn't. I mean, the guy asked for help.
Yeah.
I mean, it was his fault. All he had to do was say, "No, you know what? My brother's coming, man. He's bringing a truck, and I already got a record." Why would you ask the cop to help you if you got drugs, a gun, and some scales? Whatever.
Help me search my car for these drugs and weapons.
He may have been on the drugs. I don't know. Motion for bill of particulars. A bill of particulars is a document made by the plaintiff at the request of the defendant. It is a detailed account of the charges made against the defendant. A defendant's attorney frequently asks a motion for a bill of particulars when the plaintiff in a civil or criminal case has claimed the cause of action is vague, general, or indefinite. So if they just come in and say, you know what, I'm going to sue you for $1 million. For what? Because what? That's when you file a motion for bill in particular. Particular to what? You're suing me for $1 million for what? Oh, because you ran into the back of my car. I had all of these injuries. My car was totaled. I had neck surgery and blah, blah, blah. Then that's when they would go in and ask for that bill of particulars. Particularly for what? Oh, for all of that. Not just to sue you for $1 million. Okay? Motion to have a claimant medically examined. Defense attorneys often make a motion to have a claimant examined by an impartial expert in a personal injury case because many cases can be settled as a result of such an examination. Even if the case is not settled, the defense attorney can prepare more adequately to refute the medical testimony. So yeah, I mean, if an attorney, let's just say for argument's sake, has a doctor that he's friends with and he's like, yeah, go see Dr. So-and-so. Oh yeah, man, you're hurt. We're gonna have to do surgery. This guy wasn't even hurt. It's like, whoa, whoa, whoa. You know, we want to see, you know, the x-rays before, and we want you to go to, you know, get medically examined by one of our experts. Okay. So the guy goes like, there's nothing wrong with him. You know, so they can have it medically examined by other experts on the other side. So just because one expert is saying, you know, oh yeah, he's going to need surgery and whatever, and the other guy's like, no, I mean, this was a pre-existing injury from way back when. Okay. That's what that is. Motion for a change of venue. Motions for a change of venue are routine when a case has had widespread publicity and the defendant's attorney does not believe that the defendant can receive a fair trial in the place of original jurisdiction. Yeah. OJ case, prime example. I think they asked for a motion for venue change. I don't think it was granted. But I mean, that was on world news. It was world news. Yeah. But like something here, you know, like the guy that shot that sheriff deputy. It was on the news. It was huge news. And I think they asked for it, you know, it wasn't granted because it was heard here. But I mean, they had one, and I can't remember the case. I can't remember the case, but the court reporter was a really good friend of mine, and they took it to Victoria, which is where I'm from. And she called me, she said, hey, you know, we're going to Victoria to, you know, try this case or whatever, and it was a murder case and blah, blah, blah. And they had a change of venue, and it was granted, and it was taken to Victoria. And they stayed down there for like a month hearing this case.
How far do you go when you ask for a change of venue? Is there a distance limitation?
I mean, it all depends on how publicized that case is, I guess. You know, because like around here, you know, they all the little counties get the news from around here.
Yeah.
You know, so they get, you know, KINS and they get KSAT and whatever. So it's not going to do it much good to go down to Pleasanton or whatever when they see the news from up here. You know, it may not be able, you know, you may have to take it to like Corpus.
Does the change of venue cross the state line?
No.
No.
No, it won't go that far. It usually won't go that far.
Like in an OJ case, I mean, I don't think there's anywhere on the earth that he would have received a fair trial.
And it wouldn't. It
I
wouldn't.
mean, you know.
And they went through hundreds of jurors, I believe. Hundreds. So, I mean, you know, in cases like that, it doesn't matter. But like around here, if it happened here, you know, but it's big enough news, you know, you may have to take it, you know, maybe to Victoria or to Corpus or, you know, somewhere like that. Maybe Del Rio. I don't know. Motion to disqualify a judge. A judge may disqualify himself or herself from a case, or a lawyer may make a motion to have the judge disqualified. Disqualification only occurs because a judge may have knowledge of the case or may even have represented one of the parties. That's happened. That's happened in our court, where my judge has represented some of these guys on the criminal side, and he's like, what was your name? Oh, Mark Gonzalez. Didn't I represent you in a divorce back in '88? Oh yeah, yeah, you sure did. The judge can't hear it now, so now we send it to the other court. Hey man, you know, can you hear this case? Yeah, and you can have the judge disqualified for that. He represented somebody. He knows somebody. Maybe it's one of his family members. So I mean, there's a lot of things that a judge can get disqualified for.
What's the difference between disqualification and recusing?
Disqualification is when somebody else asks for it, like one of the attorneys asked for the judge to be disqualified. If a judge is going to recuse himself, that's what recuse is. He's going to disqualify himself, so he's going to recuse himself.
Oh, okay.
You know what, I did represent it, I'm going to recuse myself from this. Motion for continuance. A motion for continuance of a case is simply a request to postpone the trial until a later date or court session. A motion for continuance is made in a variety of reasons, including substitutional counsel, unavailability of witnesses, military. I mean, that was self-explanatory, guys. You know, when attorney gets sick, the child gets sick on the day of trial, you know what, Judge, I need a motion for continuance just a week. You know, my daughter has to have surgery and I'm not going to be able to be there. Usually it's granted, stuff like that. Motion for amendment of pleadings. Either counsel may make motions for an amendment of pleadings, including an addition or deletion of parties to a case. We have it all the time. All the time. Well, who was the father of that case? Who was the father of that child? It was so-and-so. Well, DNA came back, it wasn't him. Now we have to amend the pleadings. Who was it? Oh, it was so-and-so. Take a DNA, you know what? It wasn't him either. Now they have to amend the pleadings again. Who was it? Like, usually on the second, third time, they're just like, they're gonna start amending it to an unknown dad if they don't know who it is. And they just, you know, you try to cite an unknown dad because she doesn't even know who it is. You know, and it's happened. You know, either she was raped, she was at a party doing drugs, and, you know, maybe it was, she had sex with multiple people. You know, maybe it was a gang rape, stuff like that. I mean, I don't know who it was. But now they have to cite an unknown dad. You know, so now they have to amend their pleadings. Well, I thought it was so-and-so because that's who I was going with, but I forgot I was at that party, and we had done a lot of drugs, done a lot of drinking, and things happened. I got raped. I don't know how many people. So it could have been anybody. So that's amendment of pleadings. But pleadings can change all the time for different, you know, different reasons. Motion for summary judgment. If during preparation of the case, either party decides that no real issue of fact is to be decided at trial, a motion for summary judgment may be made requesting the court to grant judgment in favor of the party filing the motion. That happens a lot too. You know, where parties come in and it's like, you know what, we want a summary judgment, Judge. They're not able to prove their case. They can't prove their case. We have no idea who shot that dog. None. He's saying that it was my client. He can't prove that it was my client. You know, my client wasn't even here. He was out of the country. You know what? Motion for summary judgment granted. Because they were able to prove that this guy was out of the country and he thought that it was the neighbor because he came from the neighbor's backyard. Maybe somebody jumped in the backyard, shot the dog from there. Who knows? So, motion to dismiss for want of jurisdiction. If a defendant feels as though the court does not have proper authority to hear or decide a case, the attorney for the defendant will make a motion to dismiss for want of jurisdiction. Say, you know what, Judge? Both of these parties are from Houston. She filed motions down here for divorce. She can't do that. They're both from Houston. They're Houston residents. You can't hear it for want of jurisdiction. The court has no jurisdiction over this case. It needs to be heard in Houston. Okay. That's what that is. Motion for non-suit. A plaintiff's motion requesting the court to dismiss the case either with prejudice or without prejudice is referred to as a motion for non-suit. In some jurisdictions, this motion is referred to as a voluntary dismissal. When such a motion is granted without prejudice, The plaintiff may later refile the same action, but if the case is dismissed with prejudice, the plaintiff cannot file again. Very important there, okay? So they may say, you know what, we can't get this guy on this. You know, we're going to dismiss our case without without prejudice, so that we can come back and file something again. If we file something, if we find something, we know that something else is there, we just need to find it, and then we'll come back and file the case again. But we're going to non-suit this case for without prejudice. Does that make sense? Motion for a protective order. A motion for a protective order asks the court to allow one side to hold back temporarily from showing the other side certain documents or other things about the case. This type of motion asks for the court's protection for a person from harassment, service of process, and other similar situations. Such a motion can be filed regarding a notice to take a deposition. Yeah. So like if somebody's getting harassed by somebody, it's like, you know what, I need a protective order. I don't want this guy to come within 100 yards of me. Okay. You have to show why. You have to serve that person, and then you come in and have a hearing, and if the protective order is granted, then that's what that is. Motion to compel. Motion to compel is filed to require the opposing party to perform some act, such as to answer interrogatories or produce documents in accordance with a motion for production. That's exactly what that is. A motion to compel is just asking for something. It's a motion asking for something. Whether interrogatories be answered, it's like, you know what? We served interrogatories on them. They didn't want to answer them. They didn't answer anything, and they sent them back. Well, then you file a motion to compel. Well, why should we be ordered to answer? Because they have the right to ask you these questions. You filed a suit against them. They have a right to know why you're filing suit against them. And that's a motion to compel them to answer or to bring certain documents or whatever. Motion for a writ of habeas corpus. A writ of habeas corpus is a judicial word meaning someone holding a person to bring that person to court. It is used to get a person out of unlawful imprisonment or confinement by forcing the person in custody to bring that person to court for a decision on the legality of the imprisonment. A motion for a writ of habeas corpus may be made inquiring into the reason of detention or a defendant and obtaining his or her release. Yeah. Pretty self-explanatory, but you understand that?
Yes.
Motion to dismiss complaint. At the end of a plaintiff's case, and again at the end of the entire case, the defendant's attorney may ask for a motion to dismiss the complaint. It's just like a motion for summary judgment. You know what? They don't have the right to bring this case. We're asking for a motion to dismiss. Motion for mistrial. A mistrial occurs when the judge ends the trial and declares it that it will have no legal effect on either party. A mistrial occurs when a major defect in procedure occurs, such as counsel being guilty of misconduct, the inability of a material witness or party to continue on the witness stand, or the death or sickness of a juror with no alternate appointed. All of that stuff can happen in a mistrial. An attorney goes up to one of the jurors and just kidding says, you know what, that guy is guilty. You can't talk to the jury. Attorneys are not allowed to talk to the jury or say anything like that. That's misconduct. That's misconduct, and it can cause a mistrial. You know, mistrials can be caused by a lot of different things. You know, they have a motion in limine that says, you know what, we can't discuss this thing about this certain defendant. This defendant was guilty of rape back in 1984, and you know, maybe he raped somebody else. Well, you know what, they had a motion in limine that says, you know what, we don't want that brought out. We don't want that brought out in the trial. Well, then the state's attorney goes through while questioning the defendant. Well, isn't it true in 1984 you raped a lady and were found guilty? Whoa. We had already ruled on that. You weren't supposed to bring that up. Mistrial. So now, you know, the whole thing is done. You have to do it all again because of something like that. Okay? And that's all it is. A mistrial just means that they have to end the trial and do it all again because of some kind of misconduct. Motion to view premises. During a trial, a request may be made by either counsel to have the jury view a scene where an alleged criminal offense has taken place. For example, at an arson scene or a hazardous intersection, something like that. I don't know. I've never done it. I've never had it done where we've gone, you know, but it's happened. Where you have to go to the scene or whatever, and they try to, you know, put in the jury's mind exactly how this thing happened at a certain intersection, or how the arson happened and where it would have started and the fire went. Motion for new trial. After a case has been tried and a verdict is reached, defense counsel will usually make motions requesting a new trial. If the losing party feels as though the verdict is excessive or not supported by the facts, a motion may be made requesting the setting aside of the verdict. That used to happen all the time in our cases. Now it just goes up on appeal. But they can ask for what's called a de novo, which is kind of the same thing. It's a motion for new trial in front of a new judge. So, I mean, you know, it can happen, and that's what that is. Just saying, you know what, they didn't prove their case, and we want to take it up to another judge to let him hear the case, a district judge, and see if he agrees with it. And that's like a motion for new trial. A motion to strike. A motion to strike certain evidence may be made for any of the following reasons. 1, when evidence presented was apparently proper when received, but later shown to be objectionable. 2, when evidence is admitted, subject to the understanding that will be ruled on later in the trial. 3, when a witness makes a voluntary statement or testifies when no question is pending. And 4, when an answer is not responsive to the question. So any of those can be granted for any of those reasons. You know, will you state your name? Yes, he was guilty. Judge. Objection, non-responsive. Motion to strike that answer. Granted. It had nothing to do with the question that was even asked. And they're just blurting out stuff. And that's what it is. It just strikes it from the record. That doesn't mean that you don't type it up and it doesn't go. It goes on just in case it goes up on appeal. The fourth court or the people hearing it next are going to read it and say, oh, they asked that question. Oh, and it was stricken from the record, so I can't consider that. Oh, okay. But it doesn't mean because it was stricken from the record that you don't write it. You still write it. Okay, any questions about that we just covered? Any of the motions? Pretty important stuff there, but I mean, we kind of went through it a little bit quick, but pretty important stuff there on the motions. Yeah, we're going to wait on number 12. It's a little bit longer. Any questions about what we covered, guys? We covered a lot of stuff tonight, okay? If you have any questions about it, watch this video again, okay? You can go on the wiki and watch it again, you know, or whatever. So, you already read 12. 13. 14. 15. So 13, 14, and 15. And we'll cover 12, 13, 14, and 15. Okay? Read it. Go through it. Do the exercises at the end so you know exactly what to expect, so you already have your questions for next week. Okay? All right. See you next week.
Thank you.